more of a knowledge sharing. And we are making sure that all these Satell's webinars are adding to a knowledge to the CS fraternity, and of course whosoever is attending this webinar. So friends, now this is a part 2 program. We already had one program on the same topic, legal compliance under the new labor code, and we got a very good response. And somewhere we have to left it half. And then we have requested Mr. Pethe also to continue with the second part. So Mr. Pethe, good morning and welcome you to this program again.
Thank you.
So just to formalities, Mr. Pethe is almost decades plus experience, and he has worked in the corporate for a good time. And the good thing about him is using this social media very extensively. So he has more than 70,000 followers, in his YouTube channel. So, and he's a subject expert on labor law compliance. And so we welcome you, sir. And so to our team, new addition to our team, Sudhakar ji, of course, it doesn't require the introductions, but as a formalities, he has worked with the Reliance industry for more than a decade also. And probably he has overall 3 decades of experience, 3 decades plus. So welcome you, sir, to this program. And Mr. Bala, as usual, 4 decades of experience, and he has spent a lot of time with a company called Foseco India. Has all-round experience. So without taking much time, I'll request Mr. Bala to take over. Thank you.
Good morning to all of you. I have a great pleasure in welcoming you all for this session on my own behalf and also on behalf of Mehta. As Atul Mehta has already said, that we had an earlier part where we have understood what is the code, what is the introduction, what are the concept, etc. And today's session is mainly going to be regarding these 4 recent codes which have been introduced. What is the object of these codes? And what are the compliances which are actually involved? What is the actions which are required to be taken? And if the violation happens, what are the things? That is what probably our presenter is going to enlighten us. There are a couple of questions which may be coming in your mind. When you talk about these labor codes, new codes of labor laws, what happens to the IT companies, whether these are all applicable, not applicable, they are exempted? Because basically when we talk about labor, immediately our mindset goes that it is relating to only manufacturing activities, nothing else. But here what happens is, in this particular code, they have actually introduced 2 concepts. If you actually go through in detail, you will find out in industrial relations code, they are largely using the word called workers. But when it comes to the social security codes, they are using largely employees. There is a vast difference between the workers and also the employees. When we talk about the workers, yes, our mindset, it is relating to manufacturing activities, who are doing the things, etc. That is there, definitely. That is industrial relation, it is largely there. But when we talk about the employees, it covers everybody, including IT, high-tech industries. Because one good thing which has actually happened is social security code, which has actually been introduced. They actually wanted to provide those people who lost their job due to some reason or other, underprivileged people. There is a social security fund has been actually created. I think our presenter is touching upon on that. So largely what happens is the labor code is taking care of almost all the establishment. Applicability, when you come, somewhere it is applicable. When it's come to the procedural concern, maybe there are specific exemptions which have been actually given. That is one. And second thing is there again, more or less, this labor codes are aligned in line with the Companies Act, because the courts now recognizes first-time offender and a repeated offender. Of course, the first-time offender, again, first time if something goes wrong, it might have happened without, some inadvertently or by mistake, without any intention. But when it is becoming a repetitive nature, so that means that establishes purposely, diligently, with a guilty mind, people are doing it. That concept has been recognized here. In most of the cases, the first time offender, whatever the fine and penalties are provided, the repeated people, it is actually double the amount of the penalties which has been provided. Added to that, there is also a imprisonment is provided. And in some of the severe cases, there is no question of, like a compounding procedure, we can actually compound it to the imprisonment. But imprisonment is definitely must, that is there. But of course, they also consider law-abiding companies, etc., where the discretionary power has been given to the deciding authorities. Though the imprisonment can be reduced to certain extent in case of the repetitive offenses, but it cannot be totally ruled out. That is there. Okay, in some cases, if you see 6 months imprisonment, 3 months imprisonment, even 1 month imprisonment is there. But when you go to the discriminatory, whether the 1 month imprisonment can be reduced to nil, that is not the possibility. The 1 month imprisonment can be reduced at the maximum, bare minimum, 1 day at least. So law is actually looking that severity of this. So what happens is in this, I see a very good amount of the area for the labor law practice for the company secretaries who are there, because we are basically not only responsible only for the compliances relating to the Companies Act, but as the LODR regulations also speaks about for a long time, and the Companies Act 2013, which has been actually brought in, recognizes that company secretary is responsible in ensuring compliances applicable all the laws to a particular company. So labor law is also no exception to that. So I definitely feel that company secretaries can do a lot many roles in this area. It can be one of the best area for practice when it comes to that. Even in the employment also, they cannot get away with that because they are the principal officer, they are the KMP, they are actually responsible for the compliances. So naturally, this will be a highest repository for the people who are working. In my opinion, people have to study their course very detailed, and they'll have to give a presentation to the top management, to the board of directors, to understand severity and what all the things can go wrong. They'll have to take the set right. That is what it is expected actually here. So with this, I think there's a good opportunity for the people in employment as well as the working people. Understanding the law, the code, the implementation procedure is required. System is to be put in place. I think this seminar will greatly help us to understand the things in detail to all of us. I think we will be enriched at least to the greater extent, understanding the severe penalty, action, part of it, etc., which is going to elaborate. May I request Mr. Sudhakar to share his thoughts on this?
Yeah, good morning, Bala sir, and good morning, Atul Bhai, and all the participants. Good morning, Shantanu. In fact, when this program was announced, I was a bit perplexed that whether company secretaries are interested in labor laws, because company secretaries like only Companies Act, and company secretaries like the security laws only. This is what people normally say. But when I have seen the participants, 100 participants are there today, I'm indeed delighted to know that what kind of webinars Mehta and Mehta is organizing it. This might be my third or fourth webinar which I am attending. In fact, 2 webinars, I myself was a faculty for that at that point of time. But as an affirmation in the director's responsibility statement that the company has complied with all the applicable laws of the company. So it is the imperative for the company secretary, and it is the responsibility of the company secretary who has to ensure that all the laws have been complied with by the company. And also at the same point of time, he is also duty bound to give a compliance certificate to the board of directors that the company has complied with all the laws applicable with the company. So he cannot just give that certificate in an autopilot mode. But if he is a real good professional, every company secretary has to ensure. Of course, no doubt about it, it is humanly impossible to ensure each and everything, but he is the person who is responsible to put the system of compliances and to institutionalize a compliance culture in the organization. That is very, very important. I always say that it is the company secretary who is the charioteer of the organization, and especially in case of board of directors. Like the way Lord Krishna has guided Arjuna how to negotiate through the Kurukshetra war, it is the company secretary who is the charioteer as far as the board is concerned. He has to guide the board through the nuances of the compliances. Normally, people say that compliance, the company secretary is not respected in the organization, so on and so forth. We heard these things a number of times. Companies Act 2013 has given a great importance. Listing Regulations 2015 at the same point of time has recognized the company secretary as a senior manager. He's a senior management position, irrespective of the organizational hierarchical position. So on one side, he is the KMP, on another side, he is the senior management. He has to have this kind of a confidence. Apart from that thing, he has to have a great amount of knowledge, not only on the Companies Act and security laws, but also on the other fields also. I am sure and I am convinced that with the participation of 108 participants today, we are all equally concerned with every law. And we have a great faculty today, Mr. Shantanu, Pethe, who got the expertise in the legal and labor laws, courts and other things. And I'm sure that he will enrich our knowledge further as far as this is concerned with us. Thanks very much once again, Bala sir, and Mr. Shantanu, the floor is yours. Thank you.
To add to Mr. Sudhakar's, very recently in one of the case, which has been actually a RD has given a appellate order in a Madras fertilizers case actually. Some of you might have already aware of that. What has happened was there was a non-compliances relating to the AGM proceeding, etc., and other things and all these things. And initially, ROC has actually levied penalty on the directors.
Secretary Standard 2.
Yeah. And subsequently, there was an appeal has been made. Appeal was basically made for the fees revision, etc., and all these things. They felt it is higher side. But in the appeal revision, what RD has done, RD has told the moment the directors appointed the company secretary, it is the company secretary who is the compliance officer. He is responsible to take over the compliances. Any non-compliance which has happened, he is the person officer in default. Instead of charging him as an officer in default, the ROC has actually wrongly charged the directors who actually appointed them, because they are actually not responsible for the compliance, and they are not only guided by the company secretary, who is the basic person responsible for the compliances. What they have done is they have actually nullified the order of the ROC against the directors, and here directors of the ROC take a separate action against the company secretary for failing to do the compliances. This shows really the pivotal position which is occupied by the company secretary in terms of the compliances, which I thought I would bring it to the notice of the audience. Thank you. Go ahead, Mr. Shantanu.
So thank you so much, Mr. Bala sir, Sudhakar sir for kind words, and Atul sir for inviting me for this presentation. And I feel very privileged to give my presentation in front of all these big personalities. And there are few things which Bala sir has pointed out about worker and employee. There is a distinction between worker and employee. So basically, a worker is just a subset with some additional privileges as compared to employee. So this is a very important aspect. And as far as penalties are concerned, there are voices. Few people says that there are so many penalties, okay, and it should not be there. See, there is a balancing act done by the government. Penalties are provided, but there are a lot of opportunities are also given under the act to comply the law. And as far as 1 month imprisonment it is maximum imprisonment, and the court may decide that it may the person may be sent to lesser term. It is 1 month is maximum, like in cases. There may be some cases where 3 years are also there. So there is a balancing act. There is an opportunity provision also that inspector should give the employer chance to rectify the mistake. And if employer rectify the mistake, then he will not prosecute that employer. So there are so many good provisions under this labor law, and there are a few things. Sudhakar sir has rightly pointed out that CS is a key managerial personnel, and the role of company secretary will become larger and larger as the time will progress, because the legal compliances will be at higher side in future because of the information technology. Main reason is that, and the laws which are coming. So all the company secretaries, as Sudhakar sir already pointed out, that it is very impossible for any person to be aware of all the laws. But company secretary should try level best to have some sort of knowledge of all. Although he will be expert in company law, secretarial matters, no doubt about it, but he should be aware of other laws as far as possible. Now there is one case law, Mr. Bala has pointed out that directors are made liable, no doubt about it. But directors has to do business also. They cannot, look after the compliance when, especially when directors have already appointed the company secretary. So company secretary should take that job seriously, and responsibilities he should take his responsibility seriously and should try to comply with all the laws which are applicable to the companies. So with this, I will start my presentation. If you have any doubt, definitely there will be so many people, and I cannot say I'm an expert of labor laws, but definitely I'm doing a lot of research on that, and it is still going on, and I'm fully committed for that research. So if any person is having any doubt, I am fully committed to resolve the doubt. All the persons who have participated, who are there right now, they can message me if they have any question on my LinkedIn. It will be preferable medium, or they can contact me on WhatsApp also. So with this, we can start our presentation. Legal compliance under new labor laws. As everyone is aware now, there are 4 new labor codes. They are about to be implemented, and 29 existing labor laws will be replaced by these new 4 labor codes. So what we are going to do in this time period, that is 1 hour or so, it is impracticable to cover each and every aspect of these new labor codes. But what we can do is we can focus on key aspects of all these 4 codes. So for example, what I have done is in each of the code, I will focus on these 4 things. That is objective. What is the objective? So it is very important for a law person that what is the objective of the act, it should be clear to him. And then applicability, whether it will be applicable to that establishment or not. Then penalties. Penalties should, all the persons should be aware of penalties. At least they should do minimum bare requirement that it should not attract penalty. So penalty, you should be aware about it. And important forms. There are so many forms which are prescribed under these new labor codes. So all forms we will not be able to discuss, but few important forms I will highlight that you should take a note of it and try to at least maintain those forms or whenever it is applicable. Apart from that, there are a few additional points. I will try to cover a few additional points also, which are important. So this is the agenda you can see. Now in code on wages, if we talk about code on wages, if we talk about the objective of code on wages, see this particular code is focusing on the payment of wages. First thing is payment of wages, also focusing on payment of minimum wages to the employee and equal remuneration. So there is a concept, it was earlier also, there is a concept of equal remuneration, that if 2 persons are doing equal equal work or work of similar nature, they should get the same amount as wages. So you have to understand this, and the payment of bonus. So the objective is to provide the provisions related to these things. Payment of wages, timely payment of wages is important. Employer's liability to pay in time has been fixed under this code, and minimum rate of wages should be paid to all the persons who are eligible for that. So these are the things. Now, applicability, as far as applicability is concerned, this is universal act. Please try to understand that this particular code, that is the code on wages, will be applicable to all the establishment, whether small or big. So it doesn't matter. It will be applicable to all the establishments. When we talk about establishment, I just want to clarify here. Establishment means any place where any industry, trade, business, manufacture, or occupation is being carried on, and include government establishment. So try to understand that even a small shop like Kirana shop, where only one person is employed, even that will come under this code, and the employer will have to comply with this code. Now, there are certain exceptions also. As far as payment of wages, chapter of payment of wages is concerned, it will not apply to government establishment. And the payment of bonus will be applicable only to those establishments where 20 or more persons are working. So you have to note specifically that bonus will not be applicable to all establishment, only where 20 or more persons are working. Only then bonus provisions will get attracted. Now, this is all about applicability. So you have to, you should carefully note that it will be applicable to all the establishment. Now, as far as penalties are concerned, you should note very carefully. The first penalty is very important, and you should note it very carefully. What it is saying that if employer pays less amount than what is due, then it will attract 50,000 rupees of fine. So अब आप ऐसा नहीं कह सकते, you can't say कि deadline है, उसके बाद हम आपको payment देंगे, next month देंगे, like that. There are so many people, as I have seen, that they have reported that we are not getting our wages for last 2-3 months, 4 months, we are not getting. What to do? In this system, they will be able to report it immediately on the server. Try to understand, everything will be very super quick, and the employer will be answerable to this and may face penalties. So pay less amount, first time 50,000, and if he repeats this offense, then within 5 years, then the penalty will be 1 lakh rupees and 3 months of imprisonment, or both. This is all maximum imprisonment. I'm talking about maximum 3 months of imprisonment. He may be sent to jail. Now, second penalty, guilty of any other provisions. For the first time, 20,000. For repeated within 5 years, it will be 40,000, 1 month of jail, or both. So these, after these two, there is one more penalty, that is guilty of not maintaining the records. We will see what records employer will have to maintain under this act. So please note that if records are not maintained, then separate penalty is given, that is 10,000 rupees. Now, very interesting provision is there under this law, and this basically, this aspect, it shows that the government is more interested in compliance with the law instead of prosecuting or punishing the people. So here the provision says that the inspector should give opportunity to comply the employer. If there is any violation, he should give the opportunity to comply in writing with the time period specified. Please note that this is only, we are talking about code on wages. Don't apply it universally. Everywhere you will not get this luxury. But in this specific act, because it will cover maximum establishment, almost all establishment will be covered, small also. So here they have given opportunity to employer to comply with the default, make the default, and within time. And if he does so, there will be no prosecution. And if he does not follow that instruction, then definitely there will be a prosecution. Now, please remember that this opportunity will not be available to offense which is less payment to employee, less than whatever is due. So for example, if employee is having an amount or a due of rupees, let's say 15,000 in a month, and you have made payment of 14,000. I'm not saying that you haven't paid anything. You are making even a less payment. It will attract the penalty. And also please remember that there will not be any opportunity. So this particular penalty, there will not be any opportunity. Yes, but for other offenses under this, you will get the opportunity for first time if you are committing the offense. But for repeating the offenses of other provisions, you will not get this opportunity. There is another defense, or let's say escape route, that is the compounding which is provided under this act. So if employer feels that he has committed any offense, then he can go for compounding of offense under this act. And there is a clear picture about compounding. It is not like what will be the amount of compounding. It is clear that 50% of the maximum fine the employer can pay, and he can get the offense compounded. Now, please remember that no compounding will be allowed if he is committing, if he has convicted for the same offense, or the compounding was done for the same offense within last 5 years. So there should be a gap of 5 years for two compounding, or conviction and compounding, then only possible. So I think if there is any doubt in this, please ask me. Now you can ask me, otherwise you can definitely ask me later on also. But if you have any doubt in this, then please ask me, then we will go.
So, Mr. Bala, you wanted to take up the questions in the chat, Mr. Bala?
I think
yeah, we can do that.
Yeah, so why don't you take up those questions?
Yeah, I think there is a very first question is somebody is asking, what is, can you share the case law? That is what they are saying. The case law is actually nothing but it is a regional director of Chennai who actually passed an appeal order in the case of the Madras Fertilizer Limited. That is the case actually. This order is passed somewhere on 29 November 2022. So that is very clearly mentioned. It's the CS is the only person who is responsible for the compliances. So second thing is also same thing is there. Madras Fertilizer, somebody has already replied. Your voice is very difficult to understand. It might be for you only, my audio, your audio, clear audio. I think these are all only not the questions. Okay. There is only one
Mr.
question.
Mr. Shantanu,
Yeah.
one question from my side is like,
yes, sir.
hey, this you are talking about code of wages.
Yeah.
Okay. Now, when there is a minimum wages act is there, what is the difference between the minimum wages act and this code of wages?
No,
both are running simultaneously.
No, Sudhakar, what they have done, they have actually repealing all the 28, 29 acts actually. The Payment of Wages Act, Minimum Wages Act, the Bonus Act, and all those acts, which they are actually repealing it. What they have done is all the 28, 29 labor law, they have brought in 4 different codes. Although it is actually code of wages, it covers almost all the laws which are relating to the wages. That is Payment of Wages Act, Minimum Wages Act, overtime, etc. and other thing, everything it covered under one. Although it is known as the thing. Though it is not simultaneously running or something like that. Once this code is implemented, you have only minimum 4 codes. That's all, nothing else in place of the 28, 29 labor laws earlier. That is the situation.
So my request to Mr. Shantanu is that why can't you dwell upon this particular aspect also for the benefit of the participants?
So here he has put it actually. These are all the acts which are actually combined together. Now it is known as the Code of Wages.
Okay,
Yes,
okay.
sir.
I'm sorry.
Yeah.
I'm sorry. I was not,
Actually,
I
in
have
the
not
last-
attended the first part. Okay.
Because
Yeah.
Sudhakar, I'll tell you one thing, because what happened, probably you missed the last session. In the last session, when he has taken the concept of it, he has explained all these things actually during the last sessions.
Okay, my apologies then. I was
No,
not
no
aware.
problem, no
Sorry.
problem.
No problem, sir.
No problem.
So there may be some so many participants, they are joining the first time. I just want to clarify that. I think I should have clarified it earlier also.
Shantanu, somebody is asking, what do you mean by yes and yes means? I don't know where it is appearing.
Second
Actually.
and subsequent offense. Second and subsequent offense.
Okay.
These are the codings because I want to reduce the font
Okay.
content there.
And there is one question in there. Guilty of other provisions. Could you please tell us few provisions?
Yeah,
That yeah.
other provisions means all other things which are mentioned under the code of wages. Then, for example, paying less than the minimum rate of wages, that will be an offense. For that, you will attract the penalty which are prescribed for the other provision. Similarly, if there is any default in, provisions related to bonus should be paid to all the workers. 8.33 is the minimum and 20% is the maximum. And if you make any default in that, so it will be treated as the default of other provision and it will attract 20,000 rupees fine.
What is the current status of all 4 labor codes implementation?
Yeah, implementation, it is still we are awaiting for the final notification for implementation of these new labor codes. But I sincerely feels that it will be implemented within this year, that is before general elections, because in next year there will be general elections. And this government has done quite a good job and it will try to take advantage. So maybe this is the reason what I personally feel that they are, delaying this. This is one of the reasons. And they will implement these just before the election. So next year is election. So maybe this year, May or June or whatever, I think this year it will be implemented. It should be. Any other question like related to this?
Yeah, now nothing is there actually. We have done
Okay.
all those.
And just for the information for all those who are attending for the first time, 29 existing labor laws will be subsumed by these 4 new labor.
Okay. I think you should be logging it again.
There is someone is asking a question.
Uh-huh.
Tentatively, how much time organization will get to implement the new codes?
Okay.
There's no question of implementing the new code because already the 29 acts are in place. People are already complying it. Only thing is they have brought the various provision. Now what happens is the compliances, the various forms which are actually reduced in number, minimum forms are reduced now. There is a consolidated and annual return has been introduced. So they'll have to switch over from the old one to the new one. So in the process, the compliances will be minimum and there will be one consolidated form and there will be only one license instead of many licenses. Those cancellation, etc., consolidating will come. That is the act they will have to do. Probably considerable amount of the time will be done. Normally, a 6-month period is given. So that will happen when they notify in the government notification, we will get to know that.
So one good thing about this law is more of a progressive, like, you make it first time mistake, okay, we'll, levy you less penalty. And if you make it, repetitive, then, the penalty is going to be, growing like this. Which is a good sign.
That is one thing. Second thing is there, the role of the inspector has been actually enhanced. He is now no longer known as the inspector. He is actually known as the inspector and facilitator. That is
okay.
Because why the facilitator is there, as Shantanu has actually puts it, whenever certain non-compliances are there, etc., suppose some register is not maintained, it is not updated, entries are not made, etc., he won't immediately take an action against the company. He will actually give a reasonable time to rectify. He will say, all right, this is required to be done. I give you 1 month's time. Please do this, etc. So he wants to ensure the compliance is done. So once the compliance is done, no action is taken. So that is why he has to facilitate the compliances rather than, doing a policing job and taking action. That is the enhancement of the role which has been given to the inspector in the labor code.
Yeah.
So-
So now we have Shantanu back.
I
Yeah.
think
Yeah,
Shantanu is back.
extremely sorry, there was some connection issue. And I'm sure that you are able to see the screen now.
Yeah.
Yeah.
Code
Yes.
on wages. Now, there are two registers the establishment should maintain. And these are very important register. At least bare minimum, this requirement you should be aware of and you have to comply this. A register of wages, overtime, fine, deductions for damages and losses. So this is the first register that every establishment should maintain. And employees register, so details of employee should be maintained in employee register, and the wage slip should be issued. This is also very interesting. Government is very keen to that the person to whom you are paying, he should be aware of what are the deductions you are making and how much amount you have arrived at. So wage slip should be issued to each and every employee on or before the payment of wages. Now again, they have given some exceptions are there, that these three records or register, you can say, will not be applicable to employers who are employing only up to 5%. But please remember, this 5% is for those establishments who are in agriculture or for domestic purposes. So if there is a person, owner of the house, he has employed up to 5% servant in his house for domestic purposes, he need not to maintain this register. But if he has employed more than 5 servants in the household, then this will be applicable to that also. So this is a very tricky situation. I mean, this should be, people should be aware of this. This 5 is only for agriculture and for domestic purpose. Now, application. Yeah,
Shantanu,
please.
see, I don't know, Mr. Jammunathan will also agree with me.
Okay.
See, like, so if I have a big house and, I'm employing more than 5 servants in my house. So, I have a cook also, I have a 2, 3, I have a driver also, I have a other person who gardener also, something like this.
Right.
So it means that I have to issue the pay slip also every month. That's what the law
so
says.
actually, if we have to see this provision in with a combination of establishment definition. Okay. So establishment means any place where any industry, trade, business, manufacture, occupation is carried on, and it will be applicable to establishment first of all. And if, let's say, there are people who are doing the job of domestic like services, providing to any house where they are doing some businesses also, and they are doing, so that will be establishment, and there I think this provision will be applicable. I still have to do a lot more research on that, but this is the views which are coming out in this case. But what I want to emphasize here is that, let's suppose a small establishment is there with only 1 employee. I'm talking about establishment with 1 employee, not engaged in agriculture or domestic. I think we should focus on that aspect, that if there is only 1 employee, this register need to be maintained if that employee is not engaged in agriculture or domestic purposes. So this is what
question for me, Shantanu ji, is what is the understanding on this applicability to an individual? Okay, because why I say this is, it's also to do with, it's possible that in a house of 2 servants, male and another is female, both doing different, or between 2 male. So if you say the applicability is there even for domestic, where from the definition you can say occupation carried could be the word which takes that into it, but the previous acts had no applicability on the domestic or maybe people who are in the. So how far it is clear is maybe we will know only when the provisions or the. But in spite of this, we don't keep any register or things. Maybe certain people keep only from the income tax perspective for allowance of expenses and not beyond that. So this is a real devil in the whole code,
Yes, sir. See, I fully agree with you, sir. And there are certain clarification I think government will issue after some time, once these will be applicable or before that. Because these are the situations where picture is not clear, I can say. Because these are the loopholes, and the government has reserved the power of if to remove the difficulties for next 3 years. Government can issue the notifications and make the changes in the act, minor changes to remove the difficulty or give clarification. So I think there are so many points which I'm noting down actually. The government should come up with some clarification on that, and this is one of them. So to be on safer side, what I wanted to say here, to be on safer side, that we have to assume that if there is an establishment that is engaged in all these activities,
Shantanu,
and
I have got
yes, sir.
one thing here. With the due respect to you, but at the same time, the question raised by Atul and Jambunathan, because Atul has raised the question, if I have more people, more than 5 people, because I have a bigger house and I'm employing the people, etc., and other things. By going through the labor code, there are 3 things I come across. That one, they are talking workmen. Second thing, they are talking about employer. And the third thing, which is very significant, is actually establishment. So there should be a correlation between establishment, workman, and employee. Now, when it's come to the domestic, we can say workman also, we can say employee also, we can say, but the thing is, whether the domestic will be an establishment unless the eligibility condition for getting an establishment is fulfilled. According to me, I don't think it will not be. So, to my knowledge, whatever the labor law which has been announced, even today, even without any clarification which is coming out, I don't think domestic workers will be included for the purpose of this labor code. That is what my understanding after going through this. Because the establishment is not there, and domestic cannot be called an establishment unless until those specific activities have been done in the domestic.
Also, the applicability of a factory act or a shops and establishment act or any other act, and in the domestic, none of them is registered. So you are not in the premise of any.
Correct. I have at least strong view. Domestic will be out of this.
Yes, sir. Domestic will be out of course. And that is what my take on this is, that if the establishment, what we are saying, that is why I'm going for other side. That is, if there is an establishment which is engaged in so and so activities, trading, business, occupation, and there is one person even there, then it will be treated as he will have to maintain the records. If it is not for working there for domestic purpose, he is not there for domestic purpose. That is what I wanted to say. And yes, there is something which I will come up with more clarification later on, I think. So this is what I wanted to say.
In fact,
so still,
in fact, if you recollect, I think more than a decade, I think so. More than a decade or even more than that, there have been actually discussions to regulate the domestic workers. In fact, there have been regulations saying, the domestic workers registration and social security was to be discussed, etc., and all those things. But I don't think there is anything has happened there and all those things. But the only thing is the respective societies, they have been actually asked to the concerned registrar where the society is registered, no irregularity take place, etc., and other thing. That is what actually today is prevalent. I don't think there is any regulation, rules, registration, etc., will be applicable to the domestic according to me. Yeah.
There are one act actually for domestic also, as you mentioned actually. But I think I will come up with more clarification on this point. I have noted it carefully. Okay. So I will come up with that. So these are the 3 registers which establishment should maintain. And then there are 3 other forms like application for claim. See, whenever there is a claim, the employee should, file the claim within 3 years from the date on which the claim has arisen. So this is basically a limitation period. And please note it here. If you are not paying dues to the employee, if he files a complaint, which will be in digitalized mode, track will be done by the government. Everything will be, allotted a proper number, and everything will be traced out. And if employer, found guilty, then please remember, employer may have to pay additional compensation up to 10 times of the claim. So if you have not paid, let's say, a salary of 15,000, assuming that nothing will happen, and by chance he goes to the authority, and in that case, you may have to pay additional 1,50,000. So this is the severity. Now, appeal. Appeal can be done against the order of the authority within 90 days from the date of order, and application for composition of offense is also provided. So these are the things, the forms which are provided here under the code on wages. So bare minimum, these things you have to, you should be aware of it. Now, additional points, I would like to, discuss few additional points also, because these are very important points. Just a minute. So these are the points I would like to discuss with you. See, central government, appropriate government will fix the minimum rates of wages. Okay. And these minimum rates of wages, the employer should pay to every employee who is eligible for that minimum rate of wages, and the employer should be aware of what is the rate applicable to those employees to whom he has hired. And there is a concept of floor wages. That is, central government will fix a minimum floor wages, minimum rate of wages, that is the floor rate, below which the appropriate government cannot fix the minimum rate. So for example, 8,000 rupees per month is fixed as a floor rate by the central government. Appropriate government, that is the state government, central, they cannot fix the minimum rate below 8,000. They can go above that. Now, inspector cum facilitator will be appointed by appropriate government, and he will be the, the person who will be initial person who will be responsible for checking that the law is complied by all. For the same work or for work of similar nature, equal remuneration, the point related to equal remuneration says that there should be no discrimination in wages on the ground of gender. Okay. And no discrimination while recruiting or condition of employment on the ground of sex. So they are basically talking about male and female. They should not be discriminated, and in respect of payment of wages, even while recruiting, you cannot say that we prefer male or female for a particular job. This is clearly because it violates the constitutional provision also. So it is very important that everyone should note that there should not be any discrimination on the basis of sex or gender. Now, overtime wages. There is a provision of overtime wages. If employee is working for overtime, then you have to pay twice of normal rate of wages for the overtime. Now, this is also very important. I think you should note that there is a deadline to pay the wages, because less payment is very serious offense, and you have to make the payment by the deadline. So if a person is employed on daily wages, so he should be paid by the end of the shift. Okay. If he is working on weekly basis, the wage period is weekly, then you have to make the payment last working day of the week. For example, Monday to Saturday you have to make the payment. End of the second day, in case of fortnight, you have to make the payment next 2 days, basically, end of the second day. And most common is monthly payment, monthly period, wage period. You have to make the payment before the expiry of 7th day of the succeeding month. So these are the limits. The wage payable to him shall be paid within 2 working days if he is removed, dismissed, retrenched, as the case may be, or is resignation. So this is very important point. that normally employer says, okay, we will settle your account in next month or like that. No. Here, this act says that you have to settle the accounts within 2 working days if he is removed, dismissed, retrenched, or even if he has given a resignation. So I think these things you should note it carefully. Now, there are certain other provisions also. Deductions, it is very specific about deductions, that how much you can deduct from the wages of the employee. You cannot deduct whole wages because of certain reasons. So they says that deduction from wages shall not exceed 50% of the wages. Every month or whatever is the wage period, you cannot make deduction more than 50%. Deductions for specific purposes only. So there is a list of purposes for which you can make the deduction. For example, you have given the loan advances to the person, then you can definitely make deduction. He has done some, losses, so you can make the deduction. Now, no fine except acts or omission previously approved by appropriate government. So there is a difference between deduction and the fine. You are fully aware about fine. So acts and omission should be clearly defined when employer wants to levy the fine on any employee. So it should be properly defined. Approval should be taken from the government and should be put on the notice board. So every employee should be aware that this will be the fine, that if I do this and this, or if I omit to do this and this will be the fine. First of all, he should be aware, and then you can apply, levy the fine. Now, total fine cannot exceed 3% of the wages for any wage period. This is also a limit. So you should be aware, because if you do violation, the provisions will attract. Fine cannot be collected in installments. You are saying that 3% se zyada nahi ho sakta, we will do in installment. No. No fine after 90 days. So there is a limitation period for levying the fine, imposing the fine. That is 90 days from the act done or omission done. You have to impose the fine. Otherwise, you will not be able to impose fine later on. No fine on employee below 15 years of age. Specifically, law says that you cannot impose fine if a person is below 15. Now, these are about deductions and fine. If you have any question, you can ask me. Now we are moving to the bonuses.
There are certain questions which have come actually.
Yeah, please, sir.
Here he is saying, number one, is whether the code is applicable to entire India, irrespective of the states. Yes, the answer is actually yes. It applies to the whole of India, to all the states, including the union territory. Number two, normal rate of wages means, is it the basic salary alone or along with the other monthly allowances also?
Yeah. See, wage definition, are you able to hear me? I think there is again some power problem.
No, we are able to hear you.
Yeah. So wage definition itself is very big, very huge. And the last time I had covered it, so I am not covering. So whenever the law says that wages, you have to be, we are specifically talking about that portion of the whole amount, which is actually the wages.
I think you explained this in the last seminar. I think the link to the seminar is actually applicable along with your presentation. I think the people can definitely refer this because it has been well explained actually here.
Actually, it will take so much time, actually. 1 hour.
I think let us not waste on that because it has been dealt last time. People refer that. That is one.
That's the only thing. Yeah.
The participant, requested, we have uploaded all those webinars, presentations, on our YouTube channel. So if you want to know this YouTube channel to be seen regularly or alerts has to become, please subscribe to the YouTube channel of Mehta and Mehta. So Mr. Pethe's, the first part is already been uploaded to YouTube channel. So you can always browse through as per your convenient time. Yeah, Mr. Pethe.
Is it required to prepare the pay slip every time the wages is paid daily basis or weekly, etc.?
Yeah, very good question. See, when wages, it is only, it talks about wage slip. See, basic, if you dig into this wage slip, what is the purpose of wage slip? The purpose of wage slip is that the person who is receiving the amount should know what are the deductions and how he has arrived that amount. So I guess there is no clarification in this matter. So in case of daily also, we are supposed to give the wage slip on daily basis. This is what my assumption, but there may be some clarification which we may receive later on from the government.
And then what is the limit of bonus?
Sorry, bonus limit you are talking about.
Yeah.
Okay.
Are
See,
you talking about the eligibility limit or are you talking about the payment limit? What is it you are talking about?
see,
If you are talking the eligibility limit, it applies to the establishment where they employ 20 people. That is the thing. And as per the bonus rate is concerned, there is a minimum rate is there, which is equivalent to 1 month salary, which is 8.33%. And the maximum is actually 20%. That is what it is prevalent as and paid. Am I correct?
yes.
Yeah.
See, I just want to clarify here for bonus, as we have already seen, the bonus provision, I am talking about the applicability of provision will be only on those establishments which are having 20 or more person employed. Okay. Now, whether all the persons employed in such establishment will get the bonus, no. There is a wage limit which is prescribed by the government, and actually it is around 21,000. You can expect that amount. So those person only up to that wage limit, they will be eligible to get the bonus. Although company can make the payment to other peoples also, but as per law, it will be there will be a ceiling limit, and the persons, the employees who are earning up to that much, they will be eligible for bonus. And the bonus will be 8.33% of the wages, subject to minimum of 100 rupees, and 20% should be the maximum, 20% of wages. Now, bonus itself is a very complicated topic. Okay, calculation of bonus is very complicated, I can say, and it will require a full session. So you just have to remember few things: eligibility. Whether one person who want to claim the bonus, he should have worked minimum 30 days in an accounting year to claim the bonus. So these are the few important points I'm covering here. We can definitely go into detail later on. Provision of set on and set off. This is very important concept. Everybody should be aware of it if they are into it. I have explained it in other videos, my other videos. Now, first 5 years, please remember one more important point is there. For new establishment, for first 5 year, bonus will be payable only in case of profit. And after 5 years, this luxury will not be there. So you have to, the set on and set off provisions will be applicable. So if you have any doubt in this, please let me know. Otherwise, I will go forward. No bonus will be admissible due to if a person has done any fraud, riotous or violent behavior, theft or convicted for sexual harassment. So these are the, you can say in these cases, he will not be able to claim the bonuses. So
minimum wages is considered the gross salary plus basic plus VA. Now, this we won't talk about it because last time we discussed elaborately. Bonus will be calculated the minimum wages as per state rupees 7,000. Please advise. Now that 7,000 is actually gone. Now it is actually 21,000 rupees. That is the limit which is applicable today. Kindly specify the deduction which can be applicable. This was also dealt in the last video. Kindly refer. Final settlement in 2 working days. Lot of challenges. Either the process of 2 working days, what we pay at the end of the month. No, 2 working days is actually a mandatory because as you know, many organizations, that is why the relieving time is actually provided by the people whenever people are all resigning or people are all thing, etc. But the only thing is on the case of disciplinary action, etc., the people are instantly terminated. Only those cases it will be there. But 2 days is a mandatory, you have to settle the amount. But this settlement is actually regarding to the wages settlement. But gratuity, etc., there is a permitted time is available. So that you can say we have to make a form and it has to be settled within 30 days, etc. It is only pertaining to the wages settlement with 2 days working day. I don't see any challenges. It is number of days he is present. What is he eligible? Whatever the subject to the deductions. That's what I would see. Children below 15 years also to be considered as an employee.
Yes. They are employee, but with some protection. As we have seen that they cannot be levied with fine. They cannot, a fine cannot be imposed on them.
Can we appoint the employee below the 15 years? Won't it be the violation of the Child Labor Act as the minimum age of 18 years?
Yeah, see, Child Labor and Protection Act is there. The provisions will be governed by there. Here, this act talks about that, and it is not like that the child cannot work. Basically, the childs are, not allowed to work in hazardous processes. Okay, try to understand that. So otherwise, in the movies, you will not be able to see the child or serials. So childs are allowed to work with certain conditions. Child Labor Act is there, and this is not subsumed.
It is not the question of employment of the child. It is actually Child Labor Protection Act.
Yes.
Really speaking.
Yes, that is a different act altogether, which take care of, employment of child. So that is also available, I think, on YouTube. Which
somewhere you said if somebody has actually resigned, terminated, the employer has to pay within 3 days. But nowadays, people are all setting the final payment in 45 days. Is this applicable all the employee working in the MNCs also?
See, first of all, in 2 working days provision, okay, this talks about wages. Please focus on the wages. If you see the salary structure, wages will be almost, we can assume 50%, and that you have to pay within 2 days. That is what it is telling. And this is the wages. It is talking about wage payable to him shall be paid within 2 working days. For example, if a person is working for a month and he has resigned, let's say on 10th of the month, you have to make the payment of wages by 12th of the month. You cannot say that come next month. That is what they want to say. And this is only about wages. Please try to understand there are some components which will not be treated as wages. That will be the amount due. That is that will not be covered by this provision. For example, commission.
The whole idea is here is like this. The number of days is actually worked in a particular period, whatever it is, at the time of the separations, that proportionate amount has to be settled immediately to him. Whatever the other thing which is due to him, that can be settled later. That is the underlying of this law, which is actually talking about it.
Yes, sir. You are very correct. Just want to give one example to have more clarity. For example, one employee is working in an organization and the terms and conditions says that he will get a sales commission. For example, sales commission for whatever sales of that month or whatever last month. And in these cases, you have to do some calculation. There may be some cases that you will have to arrive at this figure after 1 month or 2 months. So it is not a part of wages. Commission is not a part of wages that you can pay him later on. Okay, it is only talking about the wages. If you still have any question, please, sir.
Nowadays, organizations are laying off employees. Existing employees are expected to take up more work. This means there will be an overtime, which is such employees say CSB eligible to get pay for overtime. Now here you are mistaken. Overtime is actually talking in terms of the putting the hours of work. Because if your specified hours of the work is between 8 o'clock to 4:30, if you are actually working beyond the hours of 4:30, say 6:30, 7:30, etc., then that is actually done. It is related to the time. It is nothing to do with the work. If you are taking additional responsibility, etc., and all this thing, it is between the terms of condition of the employment between the employer and the employee. What is the thing is there? So just because you are saying I am doing more work, somebody is there, I am doubling the work and doing the things, that cannot entitle you for working overtime. Overtime is totally related to the time constraint. Am I correct, Shantanu?
Normal working hours are well defined under the Act. And if a person is put to work beyond that number of normal working hours, then it will be treated as overtime and he will be eligible at the double of the normal rate of wages for overtime period.
As the profit has been defined under the Act, profit definition will not be in the labor code. Profit definition will be as per the what you call audited accounting, which we are actually governed with that. That will be the profit which will be there. Even if you are working out the bonus calculation, profit as arrived in the financial statement duly audited. From there only it is taking. You are all maybe already aware, when you are declaring the bonus, the company has to actually make that what is the allocable surplus, what is the surplus which is allocated, etc. Those statements, the profit is always taken from the audited balance sheet. Does the company need to comply with the minimum wages, PF, ESI for gig workers? Yes, gig workers are also covered in the code. But here, when you are talking minimum wages, PF, ESI, everything is actually covered under one combined code, which is now coming up, one of these 4 codes. But today there are separate codes, separate laws are there. It will be applicable for the gig workers also. Whether 3-month notice period is legal, that depends upon, because the thing is, even I have seen the companies, they give 6 months notice period. It is between the terms of the contract of the employment, between what you agree, what the employer and the employee agree. Further, they come. It will covered by the contract act. Nothing is talking about here 3 months, 4 months, 2 months, etc. and other thing and all. It is between the contract act, employment, terms of employment. Notice period will come under the contract act. Yes, of course, it will be, because you will take a help of the contract act. Bala sir, please tell us, calculation of the bonus is differ as per our branches present and all state, or the amount is same for all.
I just want to bonus calculation. See, if there are 2-3 establishment, try to understand one company, there are 2-3 establishment, and all the establishment are maintaining their records, that is balance sheet and P&L separately establishment wise, then you have to calculate the bonus establishment based on the profitability of that establishment. Otherwise, if there is no such maintenance of record establishment wise, you are preparing a single balance sheet for all the establishment, then it will be you have to refer that balance sheet for all the establishment for calculation.
Notice period of 6 months is legally valid. Of course, the terms of contract covers that, it is the legal, because any terms of government is the legal contract which is actually entered and executed, so it will be perfectly valid. Can you explain the provision of set on and set up? I think he is discussing it here. Holding salary during 3 months notice period, whether the legal. During the notice period holding, that means you mean to say 3 months period, you will not pay the money at all? Nida Court, are you there? I'm not very clear on this. So 3 months notice period is 3 months notice period. Yeah. Yes, Nida.
Yes, a holding salary for 3 months, whether it's legal.
Yeah, it will not be legal, because the end of the month, the period is prescribed, because even the monthly wages, it has to be paid 7th of the next month, unless until there is a serious disciplinary actions are there.
Okay.
You cannot hold it.
Okay.
It will violate this law.
Yeah, 6 months notice period, is it not unreasonable? There is no question of unreasonable and reasonable. It is the contract. If you actually given a contract, if you sign, you are accepting 6 months, then it is legal contract. It is valid. If you think it is unreasonable, you don't sign. You don't take up the employment. Because after signing it, you cannot argue whether it is reasonable or unreasonable. Because once both the parties enter into the agreement, it is perfectly valid. It is executable.
As far as a question related to reasonableness is concerned, it is always decided by the court, because government cannot, put anything like that. Certain acts, although prescribed, but normally when you enter into a contract, it is governed by Contract Act, and Contract Act gives freedom for parties to decide their own terms and conditions. And if it is unreasonable, it will be struck down by the court later on.
Is a lock-in period of 1 year is applicable? I'm not clear on this question. What is exactly in your mind, Magesh? Is a lock-in period of 1 year applicable?
Notice period, or which period is talking about?
I don't know. Magesh, are you there? Can you elaborate on this? Magesh, is the lock-in period of 1 year is applicable?
Lock-in period.
Yeah, I'm not getting it actually.
Lock-in period is basically in investment, we use this term lock-in
Yeah, that
period.
is right. Because whenever the securities are issued on the preferential basis, etc., they cannot sell it or transfer it for a period of particular year, 1 year, 2 year, whatever it is. That is not the lock-in period, but I am not very clear in this particular reference to the labor code, what is the lock-in period he is talking about.
I think he might be interested in knowing that can a company says that to any employee for that purpose, that if you are joining, you have to serve the company for at least 1 year. That means they want to give the terms are that you have to give 1 year notice period. This is what I think he want to ask.
Yeah, Mahesh is on the chat. Yes, Mahesh, can you just
Yeah.
you can speak online? Yeah.
Mahesh, can we hear from you?
Okay. I think he still muted himself. So, Mr. Bala and Mr. Pethe.
Yes, sir.
See,
Can I talk now, please?
Yeah.
yes.
Yeah. Locking period, I mean, if in between the employee and employer, there is a 1 year lock-in that neither employee can restrain the employer, neither employer can restrain the employee, or employee neither can leave the company for 1 year.
Yes. So see, these types of contract you can do as per the Indian Contract Act. Okay, these will be governed by Indian Contract Act. Law does not, say that you will not be able to enter this contract. But remember that whenever you do contract, if there is unreasonable restriction or unreasonable conditions you are mentioning in the contract, the court will not, validate that part of the contract. So you can do, but the court may struck down that provisions later on if it is unreasonable.
No, this is basically done for the key management, key people in the company.
Correct.
Suppose for any reason that they are doing some important project and partly they leave the company and all this. For that reason, this type of contract.
See, that is the point I have told you, that reasonableness will be there. So if a person is employed there and if he goes in middle, then the whole company will go down. So there should be reasonable, and reasonable restriction can be there while contracting with the employees. Okay, but it is finally decided by the court, and you should be always reasonable while drafting the terms of contract.
Let me answer this. See, Mr. Mahesh, particularly in IT company, the IT company spends a lot of time and money and training those staffs for 3 months and 6 months. Now, somewhere typically, in their appointment letter, they write, look, you cannot leave us, for at least he should be with us for at least 1 year. And if you leave, either you should reimburse X amount, Y amount, or probably will charge you some amount, or some penalty. So there'll be some lock-in period where we are saying to an employee, look, the company is spending a lot of money on training you for a 3 month or a 6 month. So this is more of a reasonable. So asking that amount which I have spent, the company which spends on the money on that employee, I can't expect I'll charge you 5 crores when I have spent only 50,000, something like this. So reasonability has to be there. Yeah.
Atul, to substantiate what you are actually saying, the company where I was actually working, it was a proprietary nature of the company, which was having a lot of trade secrets, etc., and other things and all. And we used to have the highly technical people who were actually sent over to abroad for getting a training for a period of 3 to 6 months time. People used to take care of his training requirement, and they used to take care of everything there. So before they undertake a overseas trip, we used to get a document executed from the concerned employee. We are providing this training for this particular purposes, etc. Upon getting the successful training, you will serve a minimum period of 2 years with this company. You cannot leave it. That we used to take signature. Should you want to leave in between the things, the compensation. If you leave after 6 months, how much? If you leave after 1 year, how much? If you leave after 1.5 years, how much? We used to put, that was actually in play. That is one. There was one more contract was there. Whenever the people are not happy with the organization, they want to leave the organizations. The company said it was actually one of the policy, and also it is circulated to the people. It is attached as a part of the employment. Should any point of time company employee on any ground, if they want to leave, they are prohibited to take up the job with the competitors. By any chance, if they are getting a job only with the competitor, they are not able to take up the job elsewhere. They should not take the job from the competitor. Instead, company will actually make 50% of the salary. They can remain at home after resigning. They need not come. but 50% of the salary will be paid to those people till such time they get the employment subject to a period of 1 year. We had the contract. So these restrictions are very much actually valid actually.
So
Okay.
all these, Mr. Bala sir has told about restrictions and conditions. These all, you can see that you can go in are reasonable. You have to prove always before the court that these are reasonable. And once it is reasonable, court will honor those restrictions.
Or not only that, in fact, I have one case law I can refer also. It is actually published one of the magazine also. There is one of the, there are 3 of the people who are working in our organization. They actually involved in the competitive activities after leaving the company within a period of 3 months or something like that. The company actually fought the case against the 3 people, and the court has actually recognized the restriction which is imposed by the company. They should not take any competitive activities, etc., and other thing at all because of the confidential nature for the period of 2 years. With the court felt it is reasonable, and those workers have been, those employees have been actually restrained doing anything. They have been told they should not involve any activities, etc., and other thing and all. Not only that, even it went to another extent that the company has got a liberty to claim the profit earned by them during that period by utilizing the confidential information. That also was there. Because when you talk about the reasonableness, yes, court recognized this reasonableness and they give the judgment accordingly.
Yes.
Okay. Thank you.
Very well explained, sir. So can we move ahead now? Now we can go ahead. Any question, or we can go ahead?
Yeah, I go back to the domestic workers because just now I remembered,
Okay, sir.
there was a Domestic Workers Welfare and Social Security Act 2010. Unfortunately, it was never passed in the parliament, at least from whatever I know. And there, the employer has been defined as a person, also a person who employs in domestic work. So it is possible that this act was not passed in order to synchronize it with this code of wages, and hence Shantanu, whatever you had this thing, probably it is going to come together and that act will be left out, but it will be incorporated here. I just thought I will come back to you on that particular topic. This act was very, very, it's this thing,
No, there has
Yes.
been a discussion from 2008 onwards on this actually, but nothing has actually progressed, nothing has actually moved. And I think by looking at the code, especially the word establishment, I don't think domestic will get covered actually. Domestic will not get covered.
Actually, there is still, the picture is not clear as I mentioned, but we should be on safer side that at least if it is an establishment which as per the definition, and if it is employee 1 worker, normal, it will be applicable. So we have to focus on that area. And as far as this domestic, as Malik sir has pointed out rightly, see, this time we have to understand that all unorganized workers are also being protected under these acts. So government want to, protect all workers who are under unorganized sector. So this may lead that it may apply here. That is the only linkage what I am getting here right now. But
I read in a big law firm. They said the place of work is clearly not defined, and it is possible that we can take it this way. And place of work would determine this domestic workers. They say that both sides are fine.
Yeah, so that is the thing. We have to wait for any clarification, I think, to be concrete about this particular. Thank you, sir.
Is there any legal provision with respect to giving the loan to employees and the recovery of the same, or the same will be governed by the company policies?
Yes.
So, yes, sir.
No, sir, please you go ahead.
No, because when you are talking about the loan, again, the providing the loan, every company has got their own policy because they normally give, housing loan, vehicle loan, etc., and all these things. If the terms and conditions are governed by the company policies, and there is nothing to do with the labor code. But only thing is, what are the deductions? When he is talking about it, he explained last time only, the deduction cannot be more than applicable limit of 50%.
50%.
That is there actually. So to subject to that, the company policy has to be aligned. That is what I think here. Okay. And then is there any provision for the new codes regarding layoff? Yes, it is definitely there. It covers the layoff also in this code, 100%.
Layoff will be covered under Industrial Relations Code,
Yeah.
which we are going to cover.
Then
There are layoff infringement.
please give name of the case law. Which case law you are talking about? I already given that Madras Fertilizers case regarding the company's thing. Acha, this other case law, what I talked to you. Yeah, I'll give you. It is actually, I think, Shivram and others versus Posico India Limited. It is decided about more than a decade ago, actually.
Can you repeat, sir?
Shivram and others.
Which High Court, sir?
Shivram and others versus Posico India Limited.
Thank you.
Yeah. It is actually published in one of the legal this thing. If I able to get the reference, I can give it to you also.
Thank you, sir.
Yeah. If employer and employee relationship, 1 minute. If employee-employee relationship is established, then a domestic can also be covered under right. No, it's not the question of employer-employee relationship. It is again, establishment they are talking. Domestic is not an establishment which is actually doing the activities which are specified for the domestic. Okay, because establishment is actually defined separately. Establishments means what? What are the activities done in the establishment? Domestic is no way actually qualifying here. Okay. In general, any employment contract or any organization, the company, society, trust, etc., the employer shall put their 100% effort and time for employer's company and shall not work for any other organization. But even Sunny employees has been provided a written permission to work for another organization by its employer, in spite of such restrictive clauses mentioned above. Is it valid document permission for such employees take up the part-time job or employment under a contract with another new organizations? I am not very sure whether employer will give a permission to take up another job in another organization, but to some extent I know, because in the organization where I was actually working, I actually has been asked whether I can be a faculty in a weekly 2 days. I can teach in the management institutes where I have the working time in the office. And when I talk to my management, my management has actually told categorically, so long as our work is actually not disturbed, you are permitted to taking a teaching up job for which we will give you the permission. A permission was actually given to me. I used to take up the classes for half a day in the morning for one of the management institute at Pune. That is actually possible, but taking of an alternate employment with another employer, I doubt very much. Very recently, the TV, especially the work from home culture has come. The moonlighting has been actually discussed. You would not have forgotten that, because when you are employed for an organization, you are employed for the whole time employment only for that particular organization. So I don't think this is correct actually. They can give you for taking up certain thing, which is, development, vocational teaching, this sort of a thing they can actually give, not for the alternative employment. I don't think so. Yeah. Yeah, somebody's already put BB Shivarao versus Posico India Limited from Karnataka High Court. Yeah, that is the right case. Thank you very much for Surbi sharing this. This is the right case. Yeah, that's all I think so in the chat box.
Okay. See, I have seen one case, one position, and I would like to know your views, because this is very typical position. There was one watchman. He was working as a security guard in a society. And what he was doing, for 12 hours, he was serving one society, and next 12 hours, he was working for another society as a security guard. He was working for 24 hours. So actually, my question is labor laws does not, they don't allow, to employee to work more than a particular hours. So this may not be legal position, what I feel, but people may do these type of things, but it will not be legal or permissible under the law. Beyond normal working hours, you cannot work. So this is gray area. I'm doing my research, and I will come up with something on this, and I will share with you. So let's move to Industrial Relations Code 2020. This is the second code. Again, we will for objective applicability penalty important. So when the objectives, see, industrial relations is very important law in terms of maintaining the cordial relations between the employer and workers. So because if relations are good, Indian economy will, there will be a boost in economy. So this is very important legislation, and it provides for registration of trade union. Please remember, registration of trade union is provided under this act. You cannot register trade union anywhere else except you have to register here only, and trade unions are for the protection of the worker. Then resolution of industrial dispute. If there is any dispute, then it will be resolved as early as possible. This is what the stress is on about. This prohibition of strike and lockout. There are very important provisions about strike and lockout. I will cover here. Procedure for layoff, retrenchment, closure, provision for standing orders, notice of change you have to give if you are any change in the terms and condition of the worker. Then there will be forums, a working committee, works committee. It will be constituted if an establishment is having more than 100 worker, 100 or more worker, and that too only will be applicable if the government pass special or general order for that establishment to form a works committee. But grievance redressal committee is mandatory if there are 20 or more workers. So you should take a note of this, at least, that there should be a grievance redressal committee. It will comprise of maximum 10 members, and there will be representative of both employer and workers in equal number. And further, there will be a representation of women also if there are women working in the labor force, and it should be in proportion to the proportion of women in the total workforce of the labor. So this is very important from compliance point of view, that you have to make sure that grievance redressal committee is formed, and your life will become more easier if you have formed this, basically, because we will see later on also provision related to this. Then there will be a reskilling fund. See, reskilling fund is provided here if the employee is retrenched, worker is retrenched, then there is an additional burden on the employer to provide 15 days of pay as a retrenchment, additional amount for retrenching employee, and it will go to this fund, and this from this fund the retrenched employee will get that amount and will apply for reskilling purposes, I guess. Prohibition of unfair labor practices. There is a separate schedule given in this act that nobody should be engaged in unfair labor practices. So these are the basic objective for of this act. Now let's talk about applicability of this act. So please remember that this act will be applicable to all industrial establishments. So it is not just establishment. These it will be industrial establishment. And what do you mean by industrial establishment? We have to see a certain definition, which we'll see later on. But before we go into the detail of industrial establishment, please note that there are certain special provision. When I say special provision, it means you have to take the previous approval of the government before providing layoff or retrenching an employee or worker or closure of establishment. Previous approval you have to take. But these special provision, please note that carefully, it will be applicable only in case of mine, factory, and plantation. So normal offices, software companies, it will not be applicable. No need to take government approval in any case. And in case of mine, factory, plantation also, if there are equal to 300 or more than 300 workers, then only the provision of previous approval for layoff, retrenchment and closure of establishment will be applicable to such industrial establishment. I think everyone is clear on this. If you have any doubt, you can ask me. There are some, there is one chapter related to standing orders. See, government will give the model standing order, and industrial establishment can adopt those model standing order as it is, or they can go for their own standing order and get it certified from the authority. So standing order chapter, that is 4, will be applicable only to industrial establishments which are having 300 or more work. Okay, so it is not about factory or mine. It is all industrial establishment where 300 or more workers are working. They should have their own their standing orders. So these two things you have to note it down. Now, it will be not applied to establishment that are not industrial establishment. We will come to that. And industrial establishment which are exempted by appropriate government. Please note that there are certain formalities and so many things, procedures are prescribed under this act. Government has got power to, exempt new establishment. I think this exemption giving power is reserved with the appropriate government, just to, encourage new establishment, industrial establishment that should not be get burdened with this. And that is the reason I think this power is given to appropriate government, that new establishment can be exempted from this for so many years. Okay, so we have to note for the
300 workers and plus is really a very, very welcome move.
Yes.
Because earlier, considering our bureaucratic and getting the approval, processing, etc., and all this thing, which is having a lot of hassles. But now industries are actually free to take their own decision in the way of doing the ease of business. So that, really speaking valid reason, if there is a shortage of raw material, if shortage of, supplies or shortage of customers or people's preferences are changing, etc., and other thing cases, there is valid reasons. This can be effectively utilized by them without getting into the legal hassle of getting the prior approval, etc., and other things and all. And the government is also equally concerned where it is actually beyond 300 workers, etc., because of the employment laws, etc., and other things and all. They want to take a stock of it. That is why the prior approval has been actually raised to 300 level, I think so. It is a very welcome move for the industrial people to take the decision doing the in their business, very ease of doing the way of business. That is what I think so. Yeah.
Yeah, 300 limit. I just want to clarify a few more points. This 300 limit is prescribed by the Act. The appropriate government can increase this limit, but they cannot decrease this limit, okay, for government approval. So state government has power that they can further increase this limit for a government approval in their respective states. So now we will talk about some of the penalties which you should be careful about this. Now, please remember that it will be very difficult for me to take each and every penalty. So I am discussing few penalties in detail so that you will come to know about this. But before this, if you want me to discuss the industrial establishment or something like that, I will take up that first. Otherwise, I will go for the penalties first, and then we will discuss about what do you mean by the term industry? What do you mean by the term industrial establishment or industrial dispute for that purpose? So let's see, we can go ahead with the penalties first. See, industrial relation code, please remember, there are heavy penalties prescribed under industrial relations code. And there are frequent, provisions talking about the jail terms also. So you have to be very careful while dealing with this act. I'm just covering few penalties one by one, so you have a better understanding of the overall penalty structure of this. First of all, they are saying the penalties will be in the range. In the range means there will be minimum penalty and there will be maximum penalty. So if there is a default, you can assume that minimum penalties will be levied if you are guilty of that offense, and you should be prepared for that. So if there is any provision which is violated like 78, 79, 80 for the first time, there will be a minimum 1 lakh and maximum 10 lakh. These are the limits provided. And if you repeat second and subsequent offense, minimum 5 lakh and it can go to 20 lakh, 6 months or both. So this is the structure. I'm just explaining. Now, you may wonder, sir, ki 78, 79, 80, what are these? We cannot cover each and every section, but for your understanding, I just want to cover one section so you will be able to understand. For example, 78 talks about layoff provisions. Okay. And this is applicable to those establishment, that is factory, mines, or like that, where 300 or more workers are employed. Okay. So 78 talks about that prohibition of layoff, no layoff of worker except badli or casual worker without prior permission of appropriate government. So this is very important, condition, and you have to meet it. Except, but please remember there are some exceptions. So you can take advantage of the exception whenever you are under those circumstances. So you have to understand those circumstances when you need not to take the approval of the previous approval of the government. Shortage of power. See, if there is no power for a particular period, then you can go for layoff without taking approval. Or there is a natural calamity. In that case, also no need for prior government approval, but you have to report it later on. Now, in case of mines, it talks about specific, this exception is specifically for mine. This is such layoff is due to fire, flood, excess of inflammable gas or explosions. So this is totally focusing on the mine aspect. Then in these cases, you need not to go for previous government approval because it will be very difficult for you to take approval in such situations. Now, if
just a minute, like,
yes,
when you say 300 workers, all those, contract workers, because, nowadays there is like most of the company, they always have their labor, on a third party contract.
yes, sir.
So whether it applies to them also?
It will be covered under that. So it is not like there is no discrimination. The act is not making any discrimination as far as benefits and counting of workers are concerned. So 300 will definitely will include the contract laborers also.
Okay.
Yeah. Now, this is the penalty for this violation. And if you repeat, there will be a minimum of 5 lakh. Okay. Now, similarly, they are saying guilty of any provision, there is violation of 67, 70, 73, 75 for the first time. Minimum 50,000 rupees you have to pay and maximum 2 lakh rupees will be there. And if you repeat that, there will be jail terms also up to 6 months. So what is 67? 67 talks about right of worker laid off for compensation. If you are laying off any worker, he has a right for compensation that is prescribed under section 67. So it says that worker except badli and casual worker. So it means badli and casual worker you can lay off without any restriction, but other than badli and casual worker who are in continuous service of 1 year. This is very important thing you have to note down, that this compensation will be applicable only if the worker is in continuous service of 1 year. If you lay off such worker, you have to pay 50% of basic plus DA for the layoff period. Okay, this is the thing which is prescribed, and if you don't pay, then it will attract the penalty. Now, let's talk about another violation. This is very important. At least I recommend each and every one to go through, I'm saying, just go through the second schedule, which talks about unfair labor practices. And it will not tolerate, the act will not tolerate unfair labor practices on the part of employer or employee. So this schedule is there. And it says that if anyone, employer or employee, violates this schedule of unfair labor practices, then minimum 10,000, maximum 2 lakh, and for repeat, there will be 50,000 and jail terms also. Now, please, I'm just taking one example. Just a minute. I want to take one example how this schedule unfolds. there are two parts in this schedule, second schedule, which talks about unfair labor practices. Part 1, there are 16 unfair labor practices pointed out, which are applicable to employers. Okay, so employers should not commit such unfair labor practices. And there is second part where 8 unfair labor practices are provided on the part of worker. So worker should also distance himself from this unfair labor practices. I will give one example of each so that you will have a better understanding of this second schedule. For example, part 1, which talks about employer, it says that to show favorism or partiality to one set of worker regardless of merit. So please remember that this will amount to unfair labor practices, and complaint can be filed and there can be penalty for this. I think you should note it carefully. It is not talking about gender. It is just talking about the one set of workers. Okay. Now, in part 2, one example, if we can take to advise or actively support or instigate any strike deemed to be illegal under this code. So what they want to say, if any person, it is talking about person, worker, who advise other person or prompt other to go for a strike which is illegal strike. So if it is illegal strike and you are suggesting people, advising, okay, go for this, no problem, then it will amount to unfair labor practice on the part of worker and will be punished under this code. So this is just two examples I have given. We can cover the whole second schedule some on other day, not today. It is not possible. So apart from this, there are other penalties for, let's say, yeah.
So Mr. Pethe,
yeah.
Mr. Pethe, now we are almost 12:45. I don't know, do we require a part 3 of this program? Because now so the timings are almost 1.5 hours. Yeah, Mr. Bala, what is your suggestion?
I think we will be requiring it because there are 2 more codes are yet to be actually covered. And one of the important code which is actually there, and the Social Security Code, which is a very new concept which has actually come.
Which is the biggest, and is the biggest.
Which is the largest one actually, which will be of great importance in the days to come when the code is getting implemented.
Yeah, so
I think
yeah, Mr. Pethe,
yeah, sorry. Please
so what is your suggestion? Should we take it forward, because now we already exited?
What we'll do is we will actually end up with this industrial relation code now. And the rest of the things we can have as a part 3. I think so. That will be better.
That will be better. I will try to wrap up within few minutes. Industrial relation code. Okay. So what I want to say, these penalties there are certain other penalties. I'm just rushing through with these penalties, so you should be aware of these. Default by a registered trade union. What kind of default? Giving notice or sending notice or document. Every office bearer or the person charged with who failed to give the notice, or then there will be penalty for those people. No office bearer or person in charge with that, then every member of the executive committee of that trade union will be liable for that default and will be penalized. Willfully make false entry like that, deceive, gives document as the copy of rules. If you are giving document saying that this is the copy of rules of trade union, which actually it is not, it will be punished. Again, deceive, give copy of rules of unregistered trade union, stating that it is a copy of rule of registered trade union, it will be penalized. Employer fails to submit draft standing order or whatever modified without, or modify at its own without following the procedure. Employer acts in contravention of standing order and again makes the repeated mistake, there will be additional fine. Worker act in furtherance of illegal strike. So no worker should be engaged in furtherance of illegal strike, otherwise it will be consequences. Employer should also not engage in illegal lockouts. So person instigate others in illegal strike or lockout, or person applies money in illegal strike or lockout, a person breaches settlement or award or continuing is there are few things like these are the normal forms. We can wrap up that there are notices and like that, not so much important, which we should focus right now. And there is a few three definitions which we can cover later on. So this is what I wanted to cover regarding the industrial relation. And there are some additional points. I think it will take some time, sir. So either we can cover.
We'll take it in a
Sorry?
part 3, Mr. Bala.
Yeah, that is true.
Yeah, part 3. Because it will take some time and rushing with the provision, I don't think it will be, there will be justice with that.
Yeah.
I think, sir, can you take the advice of, suggestions of all the participants, because these are the main people like for which matters, like if they want part 3 and continue with this, we will continue with that.
So before we
will go with part 3 also.
Yeah.
It's exhaustive, better to have it. The IR code is most important for every organization.
Yes.
So Mr. Bala, since Sudhakar is also here, we can take the one question, which I don't know, many of our practicing company secretaries, whenever I interact with them, and I'm also one of the director in a company where one of the PCA certified the housing finance company secretarial audit. Now, so just I told him, look, boss, have you covered the housing finance company regulations, which has been issued by that authority? So he said, Mr. Mehta, it is not applicable. This is not in my scope, and that is why I have not done it. So, Mr. Sudhakar, what is your view? Because there are people who are taking a very limited view. Look, labor laws and everything has to be, the management has to give us a scope. Yeah.
I say that I always say that it is up to the company secretary how much importance he wants to gain in the company. And the second thing is that most of the times for the past 3.5 decades, I'm listening that the company secretaries, especially in employment, they say that, look, nobody listens to us. So it depends upon the company secretary concerned, how much resilient and how much agile he is. So to have that agility, what he has to do is he has to expand his bandwidth. Say, for example, how many company secretaries are really bothered to go to the factory and see what is happening there? If you think that you are confining your role to the boardroom only, that is only then 4 times to 6 times maximum to the boardroom you will enter.
No. My question was whether the compliance of the labor laws should be part of the secretarial audit.
See that no 1 minute. See, as far as the compliance of labor laws is a part of the secretarial audit, he don't need to report as such. Okay, because if you make it mandatory, then the company secretaries may be in a kind of problem. But as far as the company secretaries are concerned, they have to have a look at it. They have to ensure the compliance with company laws. The labor laws also. But only thing is, Atul bhai, if you make it mandatory that the secretarial auditors have to also do the labor law audit, and I don't know really whether
I don't think so, because the moment you say secretarial audit, the scope is definitely restricted only to that. It doesn't cover anything. In fact, a lot of companies, they used to get voluntarily done an audit for all the other applicable laws, which I also done in my establishment where I was actually working. That is one. And second thing is, as Sudhakar has put it very clearly, I will tell you my own experience. First of all, this all other applicable laws concept has come by LODR regulation long time back when it was under the listing agreement.
Right.
When that came for the first time, I normally used to give the presentation to the board of directors. At least one day before the meeting, we used to meet in the evening. I used to give what has happened between the last board meeting, this board meeting, the various amendments, etc. There I brought out to the notice. Look here, boss. This is what is required as a compliance status required all the applicable laws to the company. This is what it is. The board of directors asked me, Bala, what we are required to do? Sir, I have a fundamental question. Do we have a list of laws which are applicable to this company as anybody has got it? First of all, the answer is actually no. I have been given the assignment to identify all the applicable laws in that company, which was a medium scale company, which was doing a turnover about 250 crores at that time when I left the company. It has company that time I had got two manufacturing units. One is situated near the coastal area, one is situated in Pune. I have done an exhaustive job. Even I have taken the help of the outside expert professional also. I could identify at that particular time almost about 88 laws were applicable in this company in Pune, whereas the 95 laws were applicable in Pondicherry, where the coastal area was there, because it was situated in the Panchayat Union, it was in the Union Territory, it was in the coastal area, it was also governed some particular cess act, etc., and other things and all those things. First thing is we listed down all the applicable laws first of all. Then we have gone into the detail. What are the regulations? What are the things? What is to be complied with? Whether it's a return, whether it is a payment, whether it's the annual return, half-yearly return, quarterly return. We have put the exhaustive list. Really speaking, that time we are not so much digitally advanced. Those days we used to work with the registered manual registers and fax and the tele printer, etc., telex operation, etc., and other thing and all. That is what we have done exhaustively. So there are ways and means of doing it, as Sudhakar puts it very correctly. It is the responsibility of the company secretary to at least identify all the applicable laws. He need not comply, but he has to identify who is the compliance owner for this. He has to tell to the management this is what it is. That is what he has to do proactively, which I have done in the organization.
Only one thing I want to add further here is if the practicing company secretary, though it is not part of MR3 as far as this labor laws are concerned, he can take an interest and he can tell the company secretary concerned or the management concerned that we would like to verify this also. And you don't need to be a part of the MR3, but you can give a separate management note to the company concerned that, look, there are certain issues as far as your labor laws are concerned and applicable, and the compliances are concerned. That's how you can expand your horizon.
So not only that, Sudhakar, when you said whether the company secretary visited the factory, etc., and all the same, we normally had in our unit, once in a month, the people were asked voluntarily to move around the plant and notify what are the improvements which are to be taken in relation to health is concerned, safety is concerned, etc., and other thing and all. In fact, a couple of occasions, I have given my suggestions. In two of the occasions, I have been actually awarded a certificate of appreciation for giving the valid suggestions also. So this is up to the people to take it up proactively.
Sir, my question is different. So if I'm doing an audit as a practicing company secretary, if I'm going in and doing an insurance company's audit, a secretarial audit. So do I say, look, I'm going to do only company law audit only, and there's IRDA regulations and this and that is not part of the MR3, the same? Yeah, Mr. Sudhakar.
Technically, if you say that it is not in the scope of audit for secretarial purpose, suppose if the company secretary comes tomorrow to my organization and if he says that, look, I want to do the labor laws audit also, I will definitely say, where is the scope? Secretarial audit, I will show that MR3 form only. Okay, you are supposed to give the audit report in this particular format. Same is the case with even the financial auditor also. Financial auditor, the scope of the audit is defined under the Kara report. Beyond that, only thing is the financial auditor can insist that whether if his audit depends upon a particular verification, he can go and do the audit, but he cannot report it. Say, for example, labor laws are concerned, can the financial auditor make his report on the labor laws? Answer is no, because it is not covered in the scope of audit. Same is the case with the secretarial auditor also. According to me, it is not covered in the scope of audit.
Okay. So we have Amit Gupta also.
But at the same point of time, this is an opportunity for the company secretary concerned. Take some initiative, go and do some work, tell the management that, look, there is an issue like this. We can offer our services to conduct an audit pertaining to your labor laws outside the scope of secretarial audit. That's how you can expand your horizon. That's what I'm mentioning.
Yeah. So we have Amit Gupta. He has raised his hand. Yeah, Amit, you want to? Yeah.
Sir, good afternoon.
Hi, Amit.
Yeah,
Good
I
to
must
listen your
compliment on.
voice on this webinar.
Yeah.
Yeah,
Yeah,
so I was taking advantage of the expert discussion silently without taking permission from you. But when this question was being discussed, so I thought I was part of the auditing standard board since 2016, and this issue has been discussed and deliberated at length. And I'm sure in 2015, when you were president, at that point of time, this was in implementation, and institute has consciously created a distinction between the scope of secretarial audit and the concept of industry specific laws and other laws has been brought out. So now the scope of company secretary while doing the audit has been twofold. As far as industry specific laws are concerned, you have to do 100% compliance verification.
Correct.
When I'm saying industry specific law, then of course, you were quoting, unquoting the example of insurance company. So for insurance company, the industry specific laws will be what relates to the Insurance Act and what relates to framed by the IRDA. We cannot say that company secretary is not responsible for doing the audit for IRDA laws or the insurance laws. That is definitely a industry specific law and has to be complied with. Likewise, if I am doing the audit for non-banking financial companies, then Reserve Bank of India and the NBFC regulations are definitely part and parcel of the industry specific law. If I am doing the petrochemical industry or the electricity act or power generation company, so similarly those will become the industry specific laws for that particular industry, and they will become part and parcel of audit scope. Now when it comes to labor laws, it becomes a very contentious issue as to whether any labor law particularly is a industry specific law or it is a general law. So general consensus is that it is a general law, except in case of a manpower company. Let's say we are doing an audit of a company which is doing a business of manpower supply. So labor law will definitely become a industry specific law for that. But for other industries who are into the, let's say, insurance industry, insurance business, then in those cases labor law will be required to be verified from the systems and processes perspective. So the secretarial audit, what he's supposed to verify is limited to see whether the systems and processes for doing the verification and compliances of labor laws are in place or not. How we do that? Very simple thing, that you will be doing a test check basis to verify whether the systems are in place or not, whether the people are deputed to comply with the labor laws or not. If the sufficient people and team are there for the purpose of doing compliance, whether each month return, whether each month challan has been deposited or not, is not really the scope of secretarial audit. That is what I wanted to convey.
Amit, if I am not wrong, even the audit of specific laws applicable also, that whether company secretaries are equipped to do the 100% audit, I have my own apprehensions about it. Say, for example,
in that case, sir, in that case, let's say I have been given the scope of audit of insurance company, right? And I don't have an expertise. So law does not stop you to buy out the expertise from the market, but ultimate responsibility lies on you. You cannot say that I will not take the responsibility because I have outsourced it.
No,
because
that I agree with you. That I agree. It is a part of your scope, definitely.
yes. So it is allowed, and to best of my understanding, the way I think I'll quote unquote the guidance given by the institute also in 2015, which is very categorically saying the industry specific law. There are illustrations also, and even in CSAS 4, which is the auditing standard on the secretarial audit. Now I'll request to refer that, and the guidance note also is available if you refer particular that guidance note, you will get the examples also as to what will become the industry specific law and what will not be. And recently we came out with a manual on the secretarial audit also, which contains the detailed guidance and the checklist also in this particular regard. I think that will help. But my view is very firm as far as the view of the auditing standard board was concerned, that based on what guidance institute itself has given, whatever industry specific laws are there, as you are doing the verification of compliance of Companies Act securities law, in the same manner you are required to do the verification of these industry specific laws. So the question what Mr. Mehta was raising with regard to the housing finance company or with regard to the insurance company, the answer is that the PCS firm is required to do the verification of those insurance laws or the housing finance law. There is no exception to that.
Absolutely, I agree with you.
Hello. Then you are contradicting the views suggested by the, because if I am into manufacturing activities, it means then the labor laws I have to check as a PCS. Yeah, this is what my views. Yeah, Mr. Jambunathan, you have raised the hand for a long time.
No. I wanted to share, I'm not getting into the PCS part of it, but as a good governance and whether a company secretary or
we are on a very specific issue, sir, very touchy issue. I think, yes, Shantanu, probably, I think, we can cover it up in our next part 3, because this is a burning issue. And many of
my great Sanchiti has actually put it. Forward of MR3 says company specific law and not the industry specific law. Industry is the very wide term.
I just want to say one thing is that if you are having contractual people inside is one thing, but we having worked for several years in companies, like say we are contract for a principal employer at Reliance or any of the institution we go, the labor license is issued on our name, whether my subcontractor is a limited company, listed company, whatever it is. So any issue that arises on that labor license, the litigation, the fines and the penalties is on them. So what I was trying to say is, we as a company secretary or as a finance, we always in the board takes not only your own license, but also on your license, whoever has been using it and what is the status is what, gives us a good principal employer situation.
So I think Mr. Bala, we will have a specific, I think, let's not get into detail. Next
I'm not getting it. I'm only sharing one information with you. When you raise this particular PCS, when actually secretarial audit was not introduced, which was applicable earlier, the companies which are, secretarial compliance certificate, which was there prior to secretarial audit. That particular time itself, what I had done in the company where I was working, I employed the practicing company secretary. I got a voluntary secretarial complaint certificate issued to verify. My board of directors were asking, why are you doing? You are already a company secretary, you are doing. I said, I am getting an audit of myself is done with the help of the third party, so that you are assured that I am doing the right thing. That is one thing which I have done. In addition to that, I have also entrusted the job to the same PCS. Please ensure that whether we are compliant with all the other applicable laws, I have provided that 80 laws to them. I told her, you spend the time, you ensure a separate certificate, all the other applicable laws, whether compliance is done, anything is lacking. That is what I got it done actually. In fact, these certificates have been published in the annual report of this Posico India Limited consecutively for the period of about 10 years also, which I can share.
Atul bhai, what I suggest is, since Amit Gupta is a member of the audit standards board for the past almost 7-8 years, maybe next webinar when we discuss about this particular subject, we can ask Amit to prepare himself for about half an hour or so. We can allocate to him half an hour to 45 minutes.
Yeah, Amit,
so he can update us what exactly was the ICSI point of view, what he was mentioning about the guidance note, as well as that standard 4, what he is mentioning about.
Yes, Amit.
Amit, I hope this is acceptable to you.
Your voice is not coming.
No. He's not speaking. Anyway, yeah, Mr. Sudhakar.
Yeah, so this is what I'm saying is that let Amit do a bit of study further and can update us on what ICSI view exactly, because he is there in the standard of audit, Audit Standards Board for almost 7-8 years. So he must be knowing, because I remember that in 2015, this issue was discussed. As you are manufacturing, for example, for a manufacturing company, no doubt about it, labor laws are applicable. But can we say it is a specific law? It is not so. So every industry got it. Suppose if it is a pharmaceutical industry, pharmaceutical laws are there. If it is an oil and gas industry, oil and gas laws are specific laws applicable to that particular industry. So like that, ICSI has come with a publication also, if I am not wrong, because I was associated at that point of time with that particular publication as far as the oil and gas industry is concerned. But I don't remember exactly what ultimate the outcome was. So this is what I think. Amit, you may, work
Surely,
out something in about half an hour.
Although what I explained is the exact situation, but nonetheless, I will share the documents also. I'll share it to you and the Mehta sir also.
Thanks a lot. Thank you very much, Amit.
Yeah, Mr. Pethe, sorry, we have hijacked your. We have hijacked your session.
No, sir. Actually, it is very interesting point. Actually, what is the picture in secretarial audit? What it says. This is very, very important. So I was listening carefully. So my point is here is that there may be some labor law audit which may come into existence after once these laws are implemented, and if company secretaries want to be part of the as an auditor of that to claim the audit of labor law, I think the community should take it seriously. So by the time it will come, the secretaries should be the front runner in that.
So I'll just take a minute to just update. I think Haryana state government has already given that audit to the company secretaries, and they are insisting that if you obtain a certificate from a practicing company secretary with regard to the compliance of labor laws which are applicable on the particular industry, then the immunity is given from sudden inspection and seizing of the activities. So that way, yes, we are already recognized. So I agree with the view of Shantanu ji that it's a time when we should start activation in the labor matters, and we can secure the audit pan-India basis in the from the central legislation also. I believe that's a correct thing. But I just wanted to have one small doubt from Shantanu ji with regard to the applicability of or coverage of, because you told initially that about 28 legislations are going to be submerged in these 4 codes.
Yes.
Is there Apprentice Act also going subsumed here itself, or that will continue?
No, actually, there are few labor acts which will not be subsumed. I guess child labor and protection is one of them, and articles. This one is also there. Apprentice.
Apprentice Act will continue. Actually, that is not part of these 4 codes. Actually.
So it is.
Yeah.
There are actually more than 29. They are just merging these 29 labor laws. So I'm having the list. If you want, last time I also discussed the same, but only 29 labor laws will be, subsumed, and rest of the labor laws will remain there.
Atul, I think it is already 1 ton.
Yeah.
I think we should actually close the session. Probably, we will have to go for 2 more codes. One is actually occupational safety and health code. The next is actually social security code. These 2 codes, I think, probably will schedule for the part 3, and we will discuss it, because I can see today we had as high as 150 and above people who are actually participated. That shows the interest of the people, really speaking. It seems to be a good welcoming seminar.
Not only that, actually, I have seen several times in the webinars when they begin, people will be there, and by the time after 1 hour, 50% drop, and by the time it concludes, only 25% people are there.
Now it is 104.
Now also
104 people are there. That shows the interest and importance of this topic. So let us have the third part of this. Yeah.
So we'll discuss thread by thread. Amit bhai, and Sudhakar ji, probably I'll tell Dipti also, because Dipti is also, this is very close to her heart about the second audit. She holds a different view. Of course, all of us has a views. So Amit bhai, I think with your supporting papers and all, we can take this up, because see, many of PCS are taking a different views. which I'm sorry, in 2015 when I was a president, probably the viewers, can look, you have to check, all those laws applicables. Now, how do you twist this and how do you take this? So far, nothing has happened to any PCS, so we do not have any kind of the precedent on this. But we will discuss this on a thread by thread. Yeah, Mr. Bala.
Atul, there is one more thing has come for you. Need a separate webinar on PCS area, whether all law or specific law compliance covered. That is a suggestion which actually has come.
Sure.
And then do send an email, if possibly a link of the previous session of this topic along with the today's presentation. It will help us on the next session. Really appreciate the clarity on this vast session by all respected speakers today. Thanks, team.
Yeah,
and please create a group for labor law update. Thank you for all
okay.
that.
Yeah. So, Mr. Bala, can we conclude?
Yeah, we can conclude definitely. I would really like to say today's session was really very interesting. There were a lot of questions, a lot of clarification. Our participation is very high today, actually speaking. Even now, we can see more than 100 people are all still present. Shantanu has done very excellently analysis of this labor code, which is very new. There is a need for all of us to learning. We are all in the learning processes. Very much thankful to Mr. Shantanu, very much thankful to Sudhakar. I also have my special thanks to Amit Gupta, who was kind enough to express his views. And we look forward in the next session with a presentation from your side to share the thoughts on this particular subject. I think with this, we can close this session today now because it's already 1:15. So that's all. Thanks a lot, everybody.
Thanks,
we will announce some of the part 3 after the discussion. Abdul will come back to you. Thanks a lot. Thank you very much.
Thank you, everyone. Thank you, everyone.
Thanks, Shantanu. You made this, a presentation very interesting. Anyway,
I tried.
Many questions, definitely we'll take up.
Really, thanks a lot to Shantanu.
Just
excellent job you've done. Yesterday, when I spent enough time, I thought it would not get over. I told you also.
Best. I just want to tell one more thing. If any person is having some doubts, as I already mentioned, I'm working on it. So they can post their doubts. So I will spend time on that to get some clarity on that, and I will convey.
Thank you so much.
Yeah, in the next Alco, we'll ask those people to, in case they have queries, they can write to us in the advance so that we can take it up those. Yeah.
Sure.
Thank you all. Thank you, Sudhakarji.
Yes, sir.
Yeah.
Okay. Thank you.
Thank you, Jambunathan. Next time be prepared, Yeah.
Yes.
Okay, bye.